I'm joined by three attorneys who are leading our work across three key areas, litigating from the local to the federal level as we fight for clean energy, wildlands and wild spaces, and for our democracy. This year, we've been strategically engaging in legal proceedings to stop the Trump administration from dismantling our environmental safeguards while continuing to make progress at the state level. We worked very hard during the first Trump administration and experienced quite a bit of success. And we have a roadmap based on that success during the first Trump administration. But the landscape is significantly more challenging this time. Our bedrock environmental laws have been threatened. The administration has let polluting industries direct its agenda, and it has disregarded fundamental laws. We have been fighting along with our millions of supporters, and we want to thank you for being in this fight with us. Today, we will share some insights and strategies that are behind our work. Before I turn it over to our panelists, I want to share a few examples of key victories Sierra Club had this year. First of all, I want to talk about our work on the electric vehicle charging infrastructure. During the Biden administration, there was substantial funding in the Bipartisan Infrastructure Act and the Inflation Reduction Act for an electric vehicle charging. The Trump administration tried to halt those funds. ELP lawyers developed a strategy and worked with attorneys general from 20 states and the District of Columbia to challenge the Trump administration's decision to halt those funds. And the result was over $3 billion in funding that has been restored to states. That litigation is still ongoing, but that was our preliminary victory, and it was incredibly significant. We also, in 2025, achieved two victories that were actually not litigated by in-house attorneys. And I want to raise these because they are one of the things that we are able to do as Sierra Club is bring to bear we can leverage outside counsel, pro bono attorneys from around the country who amplify our impact by representing us in cases all over, from local and state, and also in some federal cases. These were two enforcement cases under the Clean Air Act and the Clean Water Act. In Texas, Exxon was required to pay over $14 million for illegal pollution at its Baytown refinery. And in Chicago, the Trump Tower agreed to pay $4.8 million settlement to bring it and to bring its cooling water system into compliance with the Clean Water Act. So these are the largest enforcement awards in citizen suits under the Clean Air Act and Clean Water Act ever. So it's extremely significant. And then finally, another victory that just happened before Thanksgiving. We have been working on the interconnection queue, which is kind of a wonky thing, but it is basically the way that energy sources come onto the grid. And there is a long waiting line for clean energy to come onto the grid. We successfully fought an interconnection fast track proposal that the Southern Power Pool would have proposed that would have actually delayed clean energy further and benefited fossil fuels. We litigated this in the Federal Energy Regulatory Commission. We were the only party there, and we prevailed in this proceeding, so that the solar and wind that is coming online will be able to get on the grid faster, and that it will be able to take advantage of the tax credits, which are expiring. So if they didn't get onto the grid quickly, they would not have achieved those or been able to get those tax credits. So now we're going to turn to our panelists. Today, I'm joined by three fantastic attorneys from our environmental law program. Managing Attorney Sanjay Narayan, who serves as our Chief Appellate Counsel and takes the lead on cases that make their way to the Supreme Court. Managing Attorney Dory Jaffe, who leads our electric sector work in the Southeast, which is the epicenter of the data center boom. And Senior Attorney Devo Ansel, who handles some of our most significant cases to protect wildlife and public lands and waters. So we're excited to dig in. I'm going to start with you, Sanjay. As Sierra Club's Chief Appellate Counsel, you have a lot of experience working on cases that rise through the federal courts and land in the Supreme Court. How can we continue to make progress on our climate goals and defend critical environmental laws with a Supreme Court that seems hostile to regulation? How are we adapting our strategies given the current makeup and decisions coming out of the Supreme Court?
Thanks, Joanne. So I guess I have sort of three slightly different answers to this. I mean, the first is that as just sort of a preliminary matter, I don't think you can deny that having a court that seems as skeptical as this court seems towards the reach of our environmental laws, I mean that hinders our work, and it makes it at a minimum like much harder to make the kinds of progress we want to make in timely fashion. So, I will offer up a couple ways in which we are trying to adjust to sort of the new federal court regime, but as a starting point, I think you sort of have to admit that it makes our life harder. But having said that, I think there are two ways in which we have structured our work in ways that allow us to continue to make progress despite the various decisions that the current court is handing down. The first is, Dory's going to talk more about this in a minute. A lot of our strategy, especially in the electric sector, actually takes place outside of the reach of the Supreme Court. That is to say, it is mostly pointed towards state public utility commissions applying state laws and really answering pretty quotidian questions about what is the cheapest and best way to provide power to local ratepayers. And that has been true for over the past decade. I mean, that's really been the focus of our work, or at least a large focus of our work in the electric sector. And there are really sort of two ways in which that work is insulated from the kinds of things the courts are doing, the federal courts are doing. I mean, first, as I said, they're all applying state rules, and by their nature, those state rules are not things that the Supreme Court has any real power over. And then the second piece is that, while the court is, I think, skeptical as to the reach of federal environmental laws, the conservatives are a little bit more split as to how they think about state regulation and the reach of state regulation. And one thing we've seen is that there is at least an occasional majority among the court, sometimes including Justices Gorsuch and Thomas, who you don't think of as being our allies, that is willing to uphold state power to regulate, even as against sort of challenges that invoke sort of a greater federal reach. So for all of those reasons, a lot of our work takes place under state law, and we have shifted more of our work there as it has become clearer that the federal courts are going to be making it difficult to make sort of rapid progress via federal regulation. So that's sort of one big category. The other is that it has been clear that this shift is on its way since 2018-ish, I would say. And starting in 2018, we and several colleagues at other organizations began sort of tracking both what the conservative justices were saying and sort of what some of the lower court Federalist Society judges were saying, what the society itself was saying. Because while it might seem like the court is just sort of randomly whacking down environmental rules, that's actually not, I think, what's happening. There are particular areas of kind of current doctrine that the court has been concerned with. And if you pay close attention to what they're saying, you can often begin to map out what those areas are. And the trick here is a lot of that happens in places outside what we think of as traditional environmental practice. So it requires spending a lot of time listening to arguments and OSHA cases and so forth, and paying a lot of attention to the way the court is handling petitions for review and so forth. But if you do that work, we have found that we are able to at least get a sense of what some of the traps are, and then structure our cases at the outset so that we can, by and large, try to avoid those areas. And the reason that works is first, I mean, the Supreme Court itself has a conservative majority, but the lower courts are considerably more varied. And one thing we're seeing now is that the lower courts, at least, are often considerably more willing to stand up for environmental protection than the Supreme Court seems to want to. And then, the second piece of that is that our environmental laws are actually really strong. I mean, if you look at the Clean Water Act, the Clean Air Act, and Endangered Species Act, even under a very conservative reading of those statutes, they accomplish a lot, right? So you can still get a lot done, even while avoiding the kind of edgier areas of practice that the court has an interest in and seems to want to curtail. So for all of those reasons, right, there's a lot you can get done, even in federal court, and that we have gotten done without necessarily triggering Supreme Court review or engaging their interest. And just to close, to offer a little anecdote here, I mean, one of the Supreme Court's most notable interventions in our space of late was its decision to sort of stop the Clean Power Plan, the Obama administration's Clean Power Plan from going into effect, which was meant to reduce greenhouse gas emissions from the electric sector, and then eventually strike that plan down. So in theory, that's like a very sad story. But even while they did that, electric sector emissions went down by even more than that plan would have required over the same period of time. And that all happened because of the work that people like Dory are doing in state public utility commissions, and because even your sort of just basic run-of-the-mill, non-controversial Clean Air Act regulation still accomplishes enough to make things like solar and wind much cheaper and better than things like coal. And as a result of that, right, electric power emissions went down, despite the court's, quite obvious interference in the sort of scope of federal regulation in that area. So not everything moves that smoothly, but it's at least a model of the sorts of ways in which we have been able to make progress, despite everyone would concede a hostile environment in front of the Supreme Court.
Thank you, Sanjay. And I love that transition to Dory to talk about our some of our work in the states that has been continuing to be successful in decarbonizing our economy despite some of the headwinds at the federal level. We will also get a little bit later to how we need to defend those strong environmental laws that you mentioned. But first, let's go to Dory. Dory, you are working on the latest threats to our efforts to reduce climate pollution from the electric sector. The surging demand for computing power, or otherwise known as data centers, is placing an unprecedented strain on the electric grid, land and water resources, the health of local communities, and people's wallets. Utilities around the country are responding by trying to extend the life of coal plants and build more dirty gas plants, resulting in higher bills for customers. Can you share how we're confronting the challenges of data centers and how Sierra Club is advancing real solutions?
Yes, thank you, Joanne. And I guess before I kind of get to how we're kind of tackling these various challenges, just to kind of set the stage a little bit, as of June of this year, there are 43 gigawatts worth of data centers nationwide that are currently operating, and that number is expected to triple by 2030 under current estimates. So putting that into context, 1 gigawatt currently serves the entire city of Orlando. So we're looking at currently right now 43 cities of Orlando size worth of data centers in this country. And so one of the questions we always get is, are these numbers real? Are they going to burst? Are they speculative? And I don't know that we really know the answer to that just yet, but it's starting to trend a little bit down, which we're seeing is good news. So American Electric in Ohio has recently updated its data center queue, and they've seen a decrease of 17 gigawatts just since the passage of a new large load tariff in their jurisdiction. So that kind of shows us that data centers are probably puffing up their numbers and they're making it bigger when they don't actually need that much. So when it comes time to actually paying for the energy, and they're going to have to pay more under a large load tariff, those numbers are starting to go down. So that's a good trend. We're also seeing in both Georgia Power's, their recent filings, and Duke in North Carolina's filings, their numbers are now going down by 6 gigawatts and 3 gigawatts respectively. So we are a little bit encouraged by those numbers and hope they will continue to trend down. But regardless, these numbers are still big, right? They're drastic, and they are having really big impacts on the work that we do across the country. We're seeing coal plant retirement dates pushed back, and we're seeing a rush to build out new gas, which not only inhibits, our clean energy goals, but state clean energy targets as well. And one example of that is in North Carolina earlier this year, the state legislature rolled back its 2030 70% carbon reduction target because of the data center growth in that state. And a lot of this is really frustrating because big tech, your Amazons, your Googles, your Metas, they claim to have clean energy goals, and they claim that they're operating on clean energy at their data center facilities, but it's not exactly true, because a lot of times they're signing contracts for cheap wind or solar in other parts of the country, and even sometimes other countries, for that clean energy. So it's not actually doing anything for the grid in which they live in, which is disconcerting. We're also seeing signs of carbon leakage, and that's especially true due to the data center growth in Virginia, because that is the epicenter of, kind of the world's data centers. It's driving up fossil use in surrounding states like West Virginia, Pennsylvania, and Ohio. And this data center build out is also leading, as you probably guess, to increases in your residential bills. Recent studies have shown that electricity rates could rise 15 to 40% over the next 5 years simply because of data centers. So now that we've gotten the bad news out of the way, like what are we doing about it? And we're doing quite a bit. So we are monitoring cases across the country relating to data centers, both state and federal level. We're seeing about 75 cases nationwide right now, and those cases range from planning dockets to new gas plants, large load tariffs, and rate cases. And we try to intervene in as many of those as we have the capacity to take on. We're also tracking air permit applications. Data centers require backup generation in case of a power outage, and those backup generation tend to be diesel generators. So they need an air permit from the state agency in order to operate them. We're currently tracking those on a regular basis, and we have filed comments on about 50 permits nationwide so far. With respect to the impacts on residential customers, we're leading the charge on large load tariffs and convincing the public service commissions in the states to require utilities to change the way that they're allocating costs to its customers in order to make sure that it better aligns with who is causing those costs and ensuring that those entities like the data centers are actually paying for it. And in case you're wondering what a large load tariff is, it's the rate mechanism for what a data center or any customer class pays for their particular service. So for a large load tariff, it would set a certain number for how big the class is, so for a specific data center, and it would lock them into a certain length of contract. It would require collateral, and it would also require exit fees if you break your contract, as well as a minimum bill. And the minimum bill is really important because if a data center asks for 100 megawatts but only uses 50 megawatts currently, they only pay for what they use. But under a large load tariff, they would have to pay regardless of how much they actually use up to a certain percentage. So if the tariff required 85%, they would have to pay for 85 megawatts even if they only used 50. So it makes sure that they're actually paying for the resources that have to be built to serve them, which is really important for all the other classes of customers like residential. In addition to litigation, we're also hosting webinars. We speak at conferences. We've drafted reports and blogs to get the word out on data center impacts, which you can find on our website. Specifically, we issued the Demanding Better report, which is essentially a call for action for data centers to actually be part of the solution, not the actual problem. We're asking them to procure what we would call 24/7 around the clock clean energy. We want them to start engaging at the actual state commission level to stand up against the utilities keeping coal online and building out new gas to meet their personal energy needs, especially if they have their own clean energy targets. And we also want them to show up and support large load tariffs to ensure that they truly are, paying their fair share.
Great. That is a thorough explanation of a pretty wonky subject. So thank you for making it understandable to those of us who are not in the weeds on that. Can you say a little bit more about how we work directly with chapters and organizers, campaigns, folks on the ground, and what role they can play in as we do the legal and technical work at the utility commissions?
Yeah, absolutely. So we kind of do this in a number of ways. The environmental law program has attorneys that are directly connected to our individual chapters and work directly with campaign staff and the organizers and our comm staff. And we do meet regularly with them. And these are kind of our opportunities to gain, firsthand knowledge into the issues that they're actually seeing on the ground. And those can include the air impacts from diesel generators, the quantity of water that data centers use to cool down their centers, and that water usage can range up to like 1 million gallons per day every single day that they operate. They also are seeing, the noise pollution from the data centers operating, around the clock. And a lot of these data centers are located in communities. They're within miles of schools and residential areas. They're not always located in industrial commercial zones. And we've also seen issues pop up with the chapter specifically on, and this gets to what I just mentioned, siting and zoning issues. Where should they be located? And so the chapter and the campaign staff often reach out to us, and they've done this probably more recently a lot on the air issues. And I think that's mostly because in states you have an opportunity to comment on air permit applications. And so in response to that, we did develop a draft template for how you can respond to these air permit applications for diesel generators, because we want to make sure that tier two, which are the really dirty diesel generators because they're not controlled, that's not the default for data centers. We want them to kind of up their game. We want them to install solar and storage as their backup generation and not just these dirty diesel generators. Because using Virginia as an example, right now, Virginia has 9,000 permitted diesel generators from data centers alone. That is an astronomical amount, and the vast majority of them are not controlled. One simple switch to what's called a tier 4 generator would drop the nitrogen oxide emissions levels by 90%. And that's not even talking about what would happen if they actually installed battery as their backup. So we've developed some comments to help them to use as a template so that they can start, filing comments on their own in front of all of the state agencies. We've also been developing policy papers and toolkits to help them identify what are the most important issues that they should be engaging on and how to organize their communities to start speaking up at these siting meetings and these zoning board meetings in order to make sure that their voices are heard, because the data centers are doing a lot of this stuff in the dark. They're not posting it. They're not letting you know what their energy use is or their water use or even how much emissions are coming out of their diesel generators unless you ask. So we really do have to work very closely with the communities and our organizers to make sure that folks are informed before this data center just shows up in their backyard.
Thanks so much, Dory. I love hearing about how our work is, how we work with our local chapters and groups and other organizations and the folks on the ground, and how they can, it just is really amplifies our power when we work together like that. Now we're going to switch over to some of our conservation work, and I'm going to turn to you, Devo. We are seeing an unprecedented level of attacks on our public lands and waters by the Trump administration. You have developed a sophisticated legal strategy based on cutting-edge scientific research on the Rice's whale, and our colleague Karima Shonhut, who wasn't able to be here today, she has taken a similar approach in her work on polar bears in the Arctic. Can you discuss this body of work and the success that we have brought in defending wildlands and wildlife?
Yeah, thanks, Joanne. Yes, we've been working to put the most up-to-date science, in my cases, on the critically endangered Rice's whale into agency decision-making records for oil and gas lease sales, biological opinions that evaluate oil and gas development activity impacts on protected species. And we submit the science into licensing records for massive oil export facilities offshore. And until recently, we've seen the agencies are relying on outdated data that even predates the listing of the Rice's whale on the endangered species list. So I've worked closely with scientific experts who have developed models and submitted reports coordinated with our technical legal comments that demonstrate that the species persistently occurs in high-risk fossil fuel development areas that generate underwater noise, risk of vessel strike, oil spills that directly harm and could even lead to the extinction of the species. The science concludes that even the loss of one reproductive female could lead to the extinction of this particular species. So with this strong science and updating the science in these public records, we can develop stronger legal claims. For example, we won a challenge to a biological opinion evaluating oil and gas drilling activities on protected species. We were able to demonstrate, and the court agreed with us, that the agency failed to consider the latest science on the species. They have failed to account for the many types of harm and take that occur as a result of oil and gas development activities. And the agency failed to even explain how its estimated take of 12 whales from this harmful activity, how it wouldn't prevent jeopardy or even extinction of a species that has a population of approximately 50 individuals. So the court vacated the biological opinion in that case. And this year, under the Trump administration, they've issued a revised biological opinion. And not surprisingly, it's about the same or even worse in many areas than the one we challenged previously. So with our strong scientific record, we're back in court challenging the revised biological opinion on similar grounds. And we're hopeful that we will get a great outcome there. And I just want to point out that, like, with incremental improvement of species management that we will get through these legal efforts, I'm hopeful that we will stop fighting against the extinction of the species, but also like looking forward to see like full recovery and better management by the federal agencies of these species. I similarly want to highlight the work of my colleague, Karima Schoenhut, who's seen great success working with scientific experts to develop the science and modeling on how oil and gas seismic exploratory activities impact Arctic polar bears. In particular, the polar bear cubs who are born, raised, and are denned by their mothers in the coastal plain of the Arctic National Wildlife Refuge. Our models showed that under the Fish and Wildlife Services protocols, the dens were going undetected, and that the seismic and associated vehicle activities were in fact causing mothers to abandon their dens and even causing direct death to the polar bear cubs from the seismic activities. So as a result of this modeling, we won a Marine Mammal Protection Act case on take of polar bear cubs from seismic activities. By demonstrating the flaws in the Fish and Wildlife Services impact probability analyses. So we hope to take this victory forward and similarly challenge Trump's efforts to open up again the Arctic National Wildlife Refuge for oil and gas leasing. In this second round, it will take we'll have to renew our efforts with our experts to analyze now the Fish and Wildlife Services updated models, which attempt to demonstrate that seismic activity will only cause minor effects on polar bears. And I just want to point out that this work takes long-term investment, and it's extremely resource intensive, especially working with experts. But with good science and one or two great court victories under our belts, I believe that there's good change ahead in the trajectory of how our species are managed as a result of these efforts in our courts.
Thanks, Stevo. That's incredibly impressive work by both you and Karima. And it just, in terms of some of the science behind it, really groundbreaking. So that's one of the roles that our attorneys play, is being able to work directly with our scientific and technical experts and translate that into very powerful legal arguments. Stevo, I have another follow-up question for you. Can you discuss ELP's legal strategy to defend against attacks by the Trump administration and Congress on our oceans and coasts from offshore oil and gas drilling?
Sure. Yeah, in the past few months, we have seen sweeping attacks on our oceans to open them up to oil and gas, offshore oil and gas development, including in California and off the coast of Florida, which have been off limits to oil and gas leasing for decades. We have an extremely robust offshore drilling docket, but with the time I have, I'm just going to highlight a couple of our offshore drilling cases. So Trump's moves to open up the offshore areas have been sloppy. And in response, we've launched a very strategic and comprehensive litigation campaign under Trump's first administration. We won against similar sloppy moves, and we're hoping to do the same again here. Just days after Trump took office, we challenged his revocation of President Biden's withdrawals of 600 million acres of offshore areas to protect them from oil and gas drilling and development. And the court already agreed with this under Trump Trump won, when we brought a similar challenge, that the law permits presidents to protect those offshore areas from offshore oil and gas development, but does not give power to presidents, the same power to presidents to cancel those protections put in place by previous presidents. That authority is reserved to Congress. So we are hopeful again that the court will side with us on similar grounds here. Also, just last week, we filed a lawsuit challenging the first lease sale mandated by the One Big Beautiful Bill Act. So it's a mouthful. On the grounds that even though that recently enacted statute mandates that lease sale to go forward, it does not waive the agency's duties under other statutes to evaluate the lease sale's effects on the environment and on protected species and their duties to balance the resources and uses of the Outer Continental Shelf. And in addition to this, I do want to point out with this litigation how incredibly important our members are in doing this litigation and helping us to establish standing to get into court to demonstrate that our members are being injured by the oil and gas leasing, drilling, exploratory activities in the ways that they recreate in these areas, seek to observe endangered species. So we have been able to build a pretty strong basis for establishing standing with incredible support from our members and developing declarations that we submit into court with our pleadings in these cases. Lastly, I just want to point out also or raise that Trump proposed a new 5-year leasing program that opens up, as I mentioned, all our offshore areas to drilling. This is still in draft form. So there is an opportunity now for our members to submit comments on the proposed program and generally on the assault that this administration is doing to our oceans, and that we, along with our coalition partners, are developing legal and technical comments to submit on that draft program with an eye on potential litigation should that program become finalized.
Thanks so much, Devo. And please, it's really exciting to be here and have, actions that our members and audience can take, like right now, and that are so important to support the legal work that we're doing by actually putting in comments from folks, just the regular folks who care about these issues. We're going to turn now to some questions that were submitted ahead of time. So thank you to those of you who submitted those questions. And the first one is one that I'm going to take. The question is, what makes Sierra Club's environmental law program effective, and how are you finding success in this environment? I think you've heard a lot already about that, but I'll just sort of summarize here. The lawyers in the environmental law program are able to litigate at the national level and in every state. So we are in the best position to maximize our impact by advocating for and defending federal safeguards that advance campaign goals and then implementing those throughout the country. So there are times when we are working very effectively at the federal level to further to get better and more stringent and more protective safeguards. But even when in times when that's not an option at the federal level, we still work to defend those standards and also implement them state by state. And as Sanjay was saying earlier, we still have really good laws on the books. We have really good regulations on the books, and they are protective, and we can continue to make use of those. We also do much of our legal work in coalition with national and grassroots environmental groups. And we can be a leader in both spaces because of Sierra Club's national reach and because of our grassroots power. And, one thing that we haven't really talked about here, but I want to share, is that one of the things that the environmental law program has done for decades at Sierra Club is to incubate creative new ideas for campaigns. Part of the origins story of the Beyond Coal campaign was that it started as in partnership with the environmental law program. I know Sanjay was here and was one of the key leaders in developing that strategy. There are other examples include our LNG export work, our vehicle electrification initiatives, Flexible resources that we get and through individual donations enable us to identify and pursue those new opportunities where they're nascent. There's things that need to be incubated. So we haven't developed a full campaign around them yet. We haven't developed a funding stream. So it's great when we have those flexible resources so that when we have creative ideas, we can pursue them. So I wanted to ask a couple more audience questions for you all to answer. Devo, what can be done to prevent the weakening of the Endangered Species Act? That question comes from one of our listeners.
Great. So just for context, we have been involved in defending the Endangered Species Act attacks since the first Trump administration, and we do not plan to back down now. We challenged the Endangered Species Act regulation rollbacks under the first administration, and we won that in the lower court. That decision was actually overturned in the appeals court because the lower court judge did not provide an explanation of the merits based on the merits for invalidating those rollbacks. But subsequent to that, the Biden administration came in and into office and fixed many of those bad rollbacks. For those that were not fixed, we continue to litigate those rollbacks in court. Now under Trump 2, the administration has proposed another sweeping round of regulatory rollbacks. At the same time, the Fish and Wildlife Service and National Marine Fishery Service have proposed revising the regulatory definition of species take as a result of harm. And this is an attempt to gut enforcement of the Endangered Species Act prohibition on take of a protected species by lethal or non-lethal harm. So to the extent that either of these actions, the rollbacks or the revised definition of take, become final, the club is poised to work with our partners to challenge those actions in court.
Great. I'm looking forward to hearing the updates on that. Sanjay, I have a question for you. It's kind of a general question, but I think it's a good one to wrap up on for the question and answer part of our program. The question is it too late to reverse the environmental damage the Trump administration has caused? And we're only not even 1 year in.
Right. So even 1 year in, I think the answer to that is pretty clearly no. Yeah, I'll start with climate, right? Like the thing about climate change is that it's not really a fight that you get to walk away from at any point. The way that I think about this is that my daughter is 16 now. By the time she's my age, it is just vastly consequential whether 1.5 degrees to 2 degrees, like that makes a difference, but so does 2 to 2.5 degrees or 2.5 to 3 degrees, right? Each one of those increments will make a massive difference, not just to her life, but to the life of like everybody who is her age or younger. And what that means is that there's no point at which you can sort of say, well, it's too late and we're done, right? You have to kind of keep on doing the work. And the way this shapes up is that we put our collective shoulders to the wheel, and every ton of carbon dioxide or methane that you prevent from going up materially makes people's lives better, right? So in a sense, like, yes, there's damage being done. In another sense, like you don't, all that damage just means that there is more work to be done going forward. And if you think about clean air and clean water, I mean, look, I grew up in LA in the 80s. The air and water is immeasurably cleaner than it was then. And we've made massive progress. And I don't think if you step back, you should be surprised that making further progress is proving difficult. But the thing about all that is that even as the politics go one way, the technology and economics have gone in exactly the opposite direction, right? I mean, one thing that should give us all like a lot of optimism looking forward is that there are clean technologies that are emerging that are cheaper and better and economically just entirely preferable to the stuff that is causing most of the pollution. And those things all give us a little bit of a downhill slope in a practical sense, even as in a political sense, right, we're sort of looking uphill, at least in the moment. So most of this damage is, I think, either the sort that you sort of have to reverse eventually, and maybe it takes longer than you'd like, but you have to get to it, or it's entirely reversible, and essentially everything but the politics is pointing in the opposite direction.
Well, that's a great answer to move on to with our speaker lightning round, because my question for that is, what is giving you inspiration and hope this year? Sanjay, we'll start with you.
Well, I already gave you one of my answers. But in sort of a more narrow one, focused on this stuff that I pay most attention to, which is sort of the federal courts. This is like a little bit of a funny place to look for optimism because, as I said before, the courts right now are not a tremendously sort of favorable forum for our work. But at least over the long term, if I think about this, if you had told me when I started practicing, which was a while ago, but not that long ago, that we would end up where we are in the courts, I would have been, I think, really surprised the courts could change that much that quickly. But that is very much, I think, a two-edged story because if you think about it, like what caused the courts to change was, in a sense, it was just politics and actually the kind of work that the Sierra Club does really well, right? Which is a mix of grassroots and political elites kind of all being pushed in one direction. And in this case, the conservatives did like a really good job of convincing both their grassroots and the elites that it was worth focusing on the courts. But one thing you can draw from that is that these things change more quickly than you think. And here I mean, not just the makeup of the court, but also the court's relationship to the lower courts, the court's relationship to the other branches. Like all of those things have changed in ways that I think most of us would not have seen coming 20 years ago. And what that tells me is that if we do the work 20 years from now, like all those changes are available in our favor as well.
Great, thank you. I'm going to go to you next, Story. What gives you hope?
So maybe a couple things, and I kind of touched on this previously, but one of the things would be that in the sphere of data centers, with the passage of these new large load tariffs, is that we are already seeing the numbers start to go down, which does kind of confirm our suspicion of double counting of data centers. So data centers going to multiple states and multiple utilities and asking for the exact same amount of energy for a new facility. They're not going to be doing that anymore if they know that they're going to have to be paying certain amounts of money regardless of whether they use all that energy or not. And so those numbers are starting to go down. So I'm feeling a little bit better about what that forecast is starting to look like. So that definitely gives me hope. And the fact that we've already gotten 8 tariffs approved across the country, and there are 15 others that are currently pending, and those numbers seem to keep going up as we see more and more new tariffs being dropped by the utilities. But another thing that I think that is really inspiring to me is the communities that are getting involved, and they're standing up and they're pushing back against the lack of transparency regarding these data centers and these tech companies that come in and negotiate sweetheart deals with the city or the municipality or the utility in order to get, basically cheap energy, cheap land, and rezoning in order to put their facility in. And the communities have had enough. They're standing up for themselves. We were able to organize them and get them to show up at all of these meetings and let their voices be heard that, they want to know what's going to go into their backyard. They want to know how much water they're going to be using. They want to know how many diesel generators are going to be installed on site, which can be upwards of 200 diesel generators for a single data center. And if one power outage happens and that one facility turns on 200 diesel generators, that's a lot of pollution coming out of those generators. And it's not going, up into a giant stack. It's going at eye level, right? Because they don't have giant stacks attached to diesel generators. So it's been very inspiring to see them rally together and show up and protest, the lack of information and transparency from these data centers.
Yeah, that's amazing, Dory. I love to hear those stories. Devo, how about you?
Yeah, what gives me hope and inspires me is that when we do our best legal work, when we are engaged in coordination with our local chapters and our frontline community partners. I especially see this in our fight against massive offshore oil export facilities in the Gulf of Mexico, where we are concurrently litigating. We're bringing hundreds of community members to testify at hearings. We're securing thousands of written comment submissions from our members and the public. And as a result, we've stalled out or even seen projects get canceled in the Gulf of Mexico to date. In the Gulf, not one of the proposed offshore oil export facilities has begun construction or even reached final investment decision. So that's just that always gives me inspiration when we can bring all of our efforts, capacities together with legal. I think we see our best results. And I just want to also emphasize that right now we have an opportunity like that with the offshore drilling 5-year leasing program. There's an opportunity right now for members of the public to begin weighing in with public comments as we build our litigation strategy for that.
That's great, Devo. I think that we have a theme here going here, because I'm going to also answer this question. And what gives me hope and inspiration is the community behind this work. So much of what we've discussed today was made possible by the transformational gift from the Ryan family. And just as important are the many donors and supporters whose generosity provides the backbone of the environmental law program. Your support is what allows us to take on these cases, stand up to powerful interests, and defend our climate, our communities, our democracy in the courts. As you consider your year-end giving, I hope you'll keep ELP and the Sierra Club in mind. Every gift, large or small, strengthens our ability to meet this moment. Thank you for your incredible generosity and for standing with us in this work. An hour is not nearly long enough to dive into all the legal battles where Sierra Club is fighting for our future, but you've heard about a few key areas where we're working hard to defend and where your support and your voice makes a difference. I really appreciate the opportunities that Devo and Dory have brought here for you to actually take action. So I want to thank you all to all of our donors, members, volunteers, and staff who make our work possible every day.